Somewhere right now, an adult child is sitting across from a parent's lawyer, being told that the bank account they thought they'd automatically inherit isn't theirs at all. Not because anyone lied, not because of some scam, because of 4 words nobody wrote down. I only added them for convenience. Every year, families end up in court over exactly this. A parent adds a son or daughter to a checking account so bills get paid on time. Nobody discusses what happens to that account when the parent dies. And when the parent does die, 2 very different legal outcomes are suddenly on the table, and which one applies depends on evidence nobody thought to collect while everyone was still alive. This video is about that gap, what the law actually calls it, and the 2-minute conversation that closes it for good. The assumption that causes the problem. Most people who add a second name to their bank account are trying to solve a practical problem, not make an estate planning decision. A parent's hands aren't as steady as they used to be. A spouse handles the bills now that the other can't. An adult child needs to be able to walk into the bank and withdraw cash for a parent's care, so a name gets added. Nobody signs anything beyond the basic bank form. Nobody says out loud whether this is meant to be a full transfer of ownership someday or purely a practical arrangement to make life easier right now. Here's the problem. To a bank's systems and often to state law, those 2 situations can look identical on paper. Both show up as a joint account. Both usually give the second person the ability to withdraw the entire balance at any time, no questions asked. But legally, they can be 2 completely different arrangements, and the difference only tends to surface after someone has died and can no longer clarify what they meant. The 2 accounts hiding inside one label. Here's the legal distinction almost nobody explains clearly. A true joint tenancy account comes with what's called the right of survivorship. When one owner dies, the entire account passes automatically and immediately to the surviving owner. No probate, no will, no waiting. This is genuinely one of the most useful features of joint banking, and it's exactly what most married couples intend. A convenience account looks the same from the outside, same joint access, same ability to write checks or withdraw funds, but legally, the second person was never meant to actually own the money. They were added purely to help manage the account on behalf of the original owner. When that original owner dies, the money is not automatically theirs. It's supposed to go back into the estate, to be distributed according to the will, or by state law if there isn't one. Some states, including New York, have laws that spell this distinction out directly. An account explicitly labeled for convenience on the title does not create survivorship rights, no matter how the account was actually used day to day. But most states, including a large majority, don't require any specific labeling at all. Whether an account was a true joint tenancy or a convenience arrangement gets decided later, based on intent, and intent, when nobody wrote it down, has to be reconstructed after the fact from whatever evidence happens to exist. This is exactly where families end up in court. One side argues, this was always meant to be theirs when I'm gone. The other side argues, this was only ever set up to help pay bills. The money was never meant to be a gift. Both sides are often making an honest argument based on genuinely different understandings of what was intended years earlier. 4 things that are quietly at risk. Here's what's actually on the table when this distinction is unclear, and why it's worth taking seriously even in an ordinary, loving family. 1. The money can be legally pulled into a dispute you never intended. Even in situations where there was zero bad intent from anyone, other heirs can challenge whether a surviving joint owner should really keep the full balance, arguing it was a convenience account all along. This can mean months of legal proceedings and real legal fees before anyone sees a dollar. 2. A joint owner's own financial problems can reach into the account. Because a joint owner generally has full, unrestricted access to withdraw the entire balance, some states allow creditors pursuing that joint owner's own debts to reach funds in the account too, even funds that everyone in the family knows actually belong to the parent, not the child. If the child added purely for convenience runs into a lawsuit, a divorce, or serious debt, the parent's own savings can become part of that fight. 3. The account can quietly complicate Medicaid planning. For anyone thinking about long-term care costs down the road, a joint account can be counted as if it fully belongs to both owners for certain benefit calculations, potentially affecting eligibility, even when the money was always understood within the family to belong to just one person. It can unintentionally override the will. A will might clearly state that an estate should be split evenly among 3 children. But if one child was added to a bank account, and that account is later found to be a true joint tenancy rather than a convenience account, that money passes directly to them by survivorship, completely outside the will, and completely outside what the parent may have actually wanted for the other siblings. How a court actually decides if a convenience account dispute does end up in front of a judge, several factors typically get weighed together, since intent is rarely written down anywhere explicit. Courts often look at who originally funded the account. If one person deposited essentially all the money and the other never contributed, that leans toward a convenience arrangement. They look at how the account was actually used for years. Regular bill paying and modest withdrawals look different from the second owner treating the funds as fully their own. They look at the relationship between the parties. Courts are generally more inclined to presume a true joint tenancy between spouses than between an aging parent and an adult child, purely based on the more common real-world pattern. And they look at any documentation that does exist, even an informal note, an email, or a conversation a bank representative can testify to, can meaningfully shift the outcome. None of this is guesswork you have to leave to a future court, though. Every single one of these factors can be settled clearly, in writing today, which is exactly the point of this video. The fix. If your goal really is convenience, help managing bills, ATM access, nothing more, there's a cleaner tool for that: a power of attorney. A financial power of attorney lets a trusted person manage your account, pay bills, and handle transactions on your behalf, without ever making them a legal owner of the money. When you pass away, there's no ambiguity, because they were never an owner in the first place. The account simply becomes part of your estate, distributed exactly the way your will says it should be. If your goal actually is to make sure that person inherits the account automatically, the fix is just as simple. Say so clearly and in writing. Some banks let you title the account explicitly as joint tenancy with right of survivorship. Beyond the bank paperwork, put your intention in a letter, an email, or ideally directly in your estate planning documents with an attorney. Something dated, something that exists independently of the bank's internal records, something that settles the question before it ever needs to be argued. And if you've already added someone to an account and you're genuinely not sure which situation you're in, the fix takes about 2 minutes. Have the actual conversation. Ask the person directly, "When I added you to this account, was that meant to be yours someday? Or was it just to help you manage things for me?" Write the answer down. Date it. That single piece of paper can be the difference between your family settling this in a 5-minute phone call or in a courtroom. The account itself doesn't know what you meant. The bank's system doesn't know either. To both of them, a joint account is a joint account. Full stop. The only thing that resolves the ambiguity is a conversation you have while everyone involved is still around to have it. If there's a joint account in your family where the reason it was set up was never actually said out loud, that conversation is worth having this week. Not because anything is wrong right now, but because the moment it becomes necessary to clarify, the person who could have clarified it is no longer there to do so.